Your spouse cannot collect cash flow from your rental properties when you pass away. The reason being is that when you pass away with the rental properties in your personal name, they will have to go through the probate process before they can be distributed out to your surviving spouse. During the probate process, the estate owns that rental property. Your spouse does not own that rental property. And because the estate owns that rental property, all the cash flow from that rental property goes into the estate bank account. That money is not going to be distributed out to your surviving spouse until the probate process is near complete, after all the debts are paid off, and then when all the assets are being distributed out to your surviving spouse. And so if you want to make sure that your spouse gets instant access to that property when you pass away and the cash flow associated with it so they can take care of themselves financially, there's a couple different ways that we can do this. The first one is going to be that you could co-own that rental property with your surviving spouse, as joint tenants with rights of survivorship. That way, when one of you passes away, your half of the property will automatically avoid the probate process and go directly down to the surviving spouse. The other way is using a revocable trust. Now, this works whether you hold the rental property in your personal name or you hold the rental property inside of an LLC. We're going to call it an asset. So you put that asset inside the revocable trust, and then you as a trustee while you're alive has full control over that asset inside the revocable trust. When you pass away, your backup trustee will step into your role as trustee and take over the management of that asset. Then you have a couple different options on how you can handle this. So the first one is going to be you can keep that asset inside the revocable trust and allow your surviving spouse to be taken care of with that asset. And then the backup trustee is going to manage that asset on behalf of your surviving spouse so that they don't have to figure out how to manage the rental portfolio near the end of their life. When you're the one who set it all up, they don't have the energy to figure it out, and they don't really feel like figuring it all out. The other option is going to be distributing that rental portfolio or the asset out to the beneficiaries listed inside of that trust document basically immediately. You have full flexibility on how to handle the management and distribution of the assets inside that revocable trust. But either way, that asset inside the revocable trust will avoid the probate courts when you pass away, and after you pay off the debts of the estate, you can distribute those assets out per the instructions inside of that trust document.